Hi everyone, welcome to week 4. This is the lecture video for week 4. As we discussed in the intro video, this is still the lecture video, but there will be a separate short video going over kind of a recap of important information. So, in regards for the midterm exam. So this is not that video, this is the regular lecture video. So, let's just jump right in and talk about the main focus, which is the elements of crime. So, with some exceptions, all crimes require at least 3 elements. And those 3 elements are actus reus, mens rea, and concurrence of the two. This is the ideally, you've heard this before in another criminal justice class, or this should be familiar to you. This is the review part. So actus reus is criminal act, mens rea is criminal intent, and then concurrence of the two means that both are happening around the same time. So that's the very basic breakdown of it. Not all crimes require a bad result or an outcome. When we tend to think of crime and we talk about how they play out, we tend to think about the negative outcome. We think about, well, what's the outcome of murder? Somebody dies. What's the outcome of assault and battery? Somebody gets hurt. What's the outcome of robbery? Somebody loses money or loses property or loses something. So we know that in general there are bad outcomes, but not all crimes do require a bad result or a bad outcome. One of those things we're going to talk about next week is incomplete offenses, or we might not even talk about it next week, but we are going to talk about offenses and we're going to talk about incomplete offenses, and that'll make more sense when we talk about it. But the idea here is that not all crimes look the same, and they don't all play out the same way. So when we talk about the elements of crime outside of the criminal act, criminal intent, and concurrence, another 3 type of elements that we can see show up are things like causation, harm, and attendant circumstances. And attendant circumstances literally just mean specific factors that must be present. So, going over all of these elements, let's talk criminal act first. And so, a criminal act is the physical action or lack thereof, as cited in law. Now, this is the hopefully one of the easiest parts of this entire conversation, is that a criminal act is the criminal action. It's the physical action. But, as is often discussed in Intro to Criminal Justice and is repeated here, sometimes a criminal act is also not acting. It doesn't always have to be you went out and stole something. You went out and murdered someone. You went out and started a fire. No, sometimes a criminal act can be refusing to act. We talk about this in juvenile justice, where a parent has a right to act. They have a right to care for a child, and if they do not act, that is a criminal act because they had a particular reason to act and they didn't. So we're going to talk more about this. This gets a little more complicated as things develop further, but it's important to at least mention this kind of stuff. So a common requirement for criminal acts, and this is something that we don't necessarily talk about in intro, but it's important to understand, is that a common requirement is voluntariness. So when we talk about criminal actions, they're not things that are usually coerced. They can be, don't get me wrong. Coercion is its own mess, and we will talk about coercion later. But typically speaking, we understand that criminal acts are criminal because somebody chose to do it. It's a voluntary decision. And essentially, we have control over our actions. But we also know that there are some non-voluntary acts. The easy ones that we always, well, not the easy ones, but obviously coercion and being under duress is its own separate mess, and we'll talk about those. But there's other non-voluntary acts that kind of make this idea of a criminal action a little more difficult. Things like reflexes, convulsions, and bodily movements while unconscious. And when we say unconscious, this can be sleepwalking. This can be when someone's under hypnosis, when someone is being manipulated via drugs and things like that. So it's very interesting to note that we do have a basic understanding that to commit a crime, you have to be aware that you're doing the crime, but there are some non-voluntary acts that gets complicated and weird. So something that we need to talk about with criminal act is that status as a criminal act is not technically a thing. What I mean is that it's considered unconstitutional to make a status illegal. And what I mean is, when we talk about status offenses, we usually are referring to juveniles, juvenile offenders. A status offense would be truancy, not going to school, would be running away from home. Those are crimes because of one's status in life. They are viewed as a kid. Their status in society is child. So that is an illegal action because they're a child. Other status offenses are considered unconstitutional. So we have this whole issue of a status can't be a criminal act, but it can. The rules state that a status would be something that is a criminal act. The problem is it's an unconstitutional rule. So why do I say this in a weird way and kind of walk around it? Because the issue is we do have other technical status offense laws that skirt the issue of being unconstitutional. So one thing that we have to consider is that when we talk about status offenses being illegal, the concept behind why is because if somebody can control their actions, they can be legally punished. A status is something that cannot be controlled. So, some areas have made laws that are essentially anti-homeless laws, and homeless is would be a status offense. But that would be unconstitutional. So it's not really a homeless law. It's an issue with other related things, and it just happens to highly target homeless individuals. And so, yes, therein lies a problem. The other thing that we talk about in relationship to this is addiction. So, drug addiction itself cannot be made an illegal action. Taking drugs who are marked as illegal is an illegal thing, but being addicted to those drugs is not inherently an illegal action. But in the same breath, being publicly intoxicated and drunk while drinking alcohol is considered a conscious decision, not alcohol dependency or it gets weird. And that's why I'm very cautious and kind of scatterbrained in how I'm talking about this, because status as a criminal act is complicated. Status offenses are inherently complicated, and the nature of our laws in our system currently really are avoiding status as a criminal act, but still making status a criminal act. They just do it in a workaround way, and it again becomes more complicated, and it's why I'm trying to like not dive too one way or the other about it. It's important to understand that this is the nature of law and why it gets complicated. So, thoughts are not criminal acts. I think that's pretty straightforward. If you take substantial steps towards an action, it can act as intent, which then can be related to criminal action. But just thinking about committing a crime is not a crime. No matter what anybody tells you, just thinking about it is not enough. And as I said, there's omission to act or failure to act. This is related to the physical action or lack thereof. In cases where there's a requirement of a legal duty to act, that now creates a new element to the crime. And we're going to actually talk about that, I believe, separately. Yeah, we're going to talk about that on the next slide. So let me wrap up my thing on possession as a criminal act, and then we'll move on. So, possession can be a criminal act. So when I say possession, I mean ownership. So obviously things like illegal contraband, drugs, weapons, those are the types of things that tend to be the legal form of possession being a criminal action. So when we talk about possession, there's a difference between actual possession and constructive possession. Actual possession is where the object in question is physically on the person. Constructive possession means that the object is within the person's control, meaning that it might not be necessarily on them at this time, but given 5 minutes, they can get a hold of it. They have control over it. They can determine when to use something and if to use something. So possession itself, having an illegal object, is considered a criminal act. So, omission to act and failure to act. Like I said, this is when there is a legal duty to act. And so, specifically, each of these three sub-situations are what we're referring to when we're talking about a responsibility to act, a failure to act, if would be the legal action. And that's where the first one, where a statute creates a legal duty to act. So this one, really straightforward and easy. Some law was written down that says that this group of persons has to do this particular thing, and if you don't do it, it's considered illegal. Believe it or not, and I know some people get really weird about this one, but you have the duty to file your taxes annually. Some people be like, here's the one trick to saving money is don't file your taxes. Guess what? That's a failure to act. There are statutes that say that you are required to, file your taxes and accurately report your income to the federal government every year. By not doing so, you are failing to act. That is the criminal action. Other things that are related to this, some of the other real obvious ones are healthcare professionals. When an individual comes into a hospital or ER with a gunshot wound, not almost, all healthcare facilities are required by law to report any kind of gunshot wounds. If they do not, that is a failure to act. That is an illegal action. And then the same goes with child abuse. If you are a mandatory reporter at any level and somebody reports or implies child abuse and you do not report it, that is a failure to act. That is something that you are required by law to do. So that's why I said this is the pretty straightforward one. There are also, because people have asked in the past, some states have Good Samaritan statutes, Good Samaritan laws, which essentially say if an individual is in extreme duress or needs emergency help, and you are acting in the best interest to help them, they can't sue you and charge you criminally for that action because you were actually doing something to help. It's a whole complicated matter. But the idea is that you have a duty to act to assist someone in an accident or emergency situation. That's the other part of that statute creating a legal duty. That's for anyone across the board. There are laws that say this group of people or these people have to do it. The second situation is where a contract requires a legal duty to act. So, this is where, unlike the previous one where it's a written law, instead of it being a written law, it's more of a contract that you have signed into willingly agreeing to it. So these are things like physicians, when on duty, they have a right, well, not just a right, but a requirement to help patients. If they are not helping a patient because they have personal issues with them, that's going against their actual right to, or their legal responsibility to act. A failure to act would be, they're a doctor, they're supposed to be helping their patient. They chose not to help the patient because they're a criminal. That goes against that whole thing. They can be charged with a failure to act. Another example is a lifeguard. If a lifeguard is on duty and they refuse to save someone who's drowning, that is a failure to act. They are held responsible because part of the legal contract that you got into by saying I will be a lifeguard is to save people in that situation when you were on the job. And then the last situation is an interesting one because it's a special relationship between partners that creates the legal duty to act. So, first one is a law says it. Second one is there's a contract that is an agreement. The third one is there's just a relationship. It doesn't have to be written down somewhere, but there is a special bond that makes this legal duty to act. So the obvious easy ones are things like parent, child, and spouse or partner, where it is the parent's responsibility to care for a child. Technically speaking, if you are in a committed relationship and you are legally bound to a person, you have a duty to act and care for them and ensure that their well-being is taken care of. If you are not acting in the right way, you can be a failure to act. The other one that's interesting to talk about is the employer-employee relationship. Much like the contract, there is some kind of legal description of what is and is not required, but at the same time, if an employer has a duty to care for their employees, in other words, ensure that they have a safe working environment, that they have all the basic needs met, and they refuse to do it, that would be a failure to act. And you could connect it to this special relationship. Even if their contract doesn't specify that their responsibility is to ensure that the business operates smoothly, the special relationship, that power balance between an employer and an employee, is a strong enough argument to say there should be some kind of legal action. So that's a weird sub one that I know some people don't quite necessarily think of when we talk about it, but it's important to mention. All right, so the second element of crime is criminal intent. And I don't know how else to say it other than it is the key to criminal grading. When we are deciding the seriousness of a crime, the grading scale of crimes, intent matters. If somebody does not intend to actually commit that particular crime, then it's a different conversation. If somebody had full intention to commit that very crime, it's a different conversation. If the person intended to do a very different crime and this outcome happened to happen, it's a different conversation. The person had no idea that their action was going to result in this, that's going to be a different conversation. You see what I mean? The key to all this is intent. And so we're going to talk about different types of intent. We're going to talk about malice aforethought, specific intent, and general intent. We'll talk about that in just a second, but I want to talk about what malice aforethought means. And also we need to talk about what malum in se. Malum in se, which roughly is evil intent, is the worst level of intent that we have. It's literally the only thing we connect it to is murder. The highest big one. And malum in se is the idea that the evil intent is with a lack of intent, but the criminal act, let me start that again. Malum in se, the evil intent, is that the decision to commit the crime was for the most serious purpose, to see out that exact offense. A malice aforethought is usually designated for murder only. It's first and second degree murder, and the idea is it's the intent to kill. There was malice aforethought. There was evil thinking before the action. So it's typically, when we talk about intent, the ranking is malice aforethought's the most significant, most serious. Specific intent is where there's a high culpability, except for murder. Murder is malice aforethought. So what I mean by high culpability is that the individual had very clear intentions to commit that said crime. There's a high culpability that they were going for that exact thing. Obviously, the only thing that's not counted is murder, because that's malice aforethought. So very specifically, most states don't distinguish between specific intent and general intent. So for all intents and purposes, most states have just the malice aforethought for murder and then intent. And that's for the rest of it. However, judges recommend and guide juries on the different levels of intent with common definitions. And the reason for this is exactly what actually a lot of you talked about in your case study response 1, is that we have to guide our juries in understanding things. So even though at the state level, at the larger legal level, we don't necessarily define them differently, we do for our everyday people, because they need to understand the difference between, oh, they clearly wanted to do this, and okay, they kind of stumbled into it. So typically, if we're going to be defining a difference between specific intent and general intent, we're going to say that specific intent is acting with a more sophisticated level of awareness of the illegality of the action. In other words, they did the action with the pretty good idea that it was wrong. And then general intent is the lower level. The intent was to perform an action. If the individual acts without the desire to bring a certain result, aka they didn't really have a specific intent, it's defaulted to general intention. Because intent is mental, it is difficult to prove. And I want to say that again and emphasize that. Because intent is mental, it's difficult to prove. So we understand that intent is important. It's a big component of understanding criminal levels and grading a criminal action. But we also need to know that it's really hard to prove, because how do you prove somebody was in that right mental state? How do you prove that person was doing that exact thing for that exact reason in that exact way? It's very difficult. And so What we have to do is make inferences. We have to make educated guesses based off of the information we have available to us and through conversations and interrogations with the individual to find out where their mental state was. So, this is an important part of intent. With intent, we need to talk about motive. Motive is the reason for an action. Don't get me wrong, intent is what this is. Motive is part of intent. Intent is the reason behind it, so motive is the more focused reason for an action. Typically, motive can generate intent, support a defense, and determine sentencing. And so this is another thing that we've talked about in other classes before, but the Model Penal Code in the United States actually divides intent into 4 states of mind that they refer to it as. And that's purposely, knowingly, recklessly, and negligently. So purposely is literally with the direct intention to commit the direct act. Purpose intent means that you intend to commit the crime that you wanted to commit. You knew the outcome and you did it anyway because that's what you wanted. Your motive was to commit that very crime and have that very outcome happen. Knowingly is where you are aware of the nature of the act and its consequences. So knowingly, when coming to a motive, is you know your action could lead to this particular outcome. You know what you are looking for, but it isn't necessarily what your intention is. But you knew it was possible. Recklessly is you know it, but you consciously disregard the risks involved when a reasonable person wouldn't. And so it's important to know the difference between purposely and recklessly. Purposely, you decide to do it because you want that outcome. Recklessly says, I know the risk, but I'm going to do it anyway. Not that you want to have that outcome, but you just don't care. And negligently is where you lack awareness of the nature and of the crime and the consequences involved. In other words, you just don't know. Hence, negligent. You should know the rules of your area, but if you do not know them, that is on you and you are being negligent. So motive is important to understand when we talk about intent. So related to intent is liability. And liability just means that somebody else is connected to the crime. When we talk about liability, it really has to do with an individual who is somehow connected. So when we talk about liability, we break it into 2, strict liability and vicarious liability. And these matter. So strict liability is essentially a one-to-one connection. The exception to required criminal intent, because typically related to issues of public health, safety, welfare, vehicle codes, and tax violations. Strict liability holds the idea that if you are committing a particular action that has strict liability, you don't need intent. If you are threatening to cause damage at a public event where it will matter to the safety of the entire population of a town, you don't need any kind of intent to charge someone. There's strict liability related to it. If you are... That should be welfare, not well-face. I don't know why I put well-face. That's a clear typo. I apologize there. But if you are going to be impacting and affecting a large group of individuals, typically your intent doesn't necessarily matter. Okay? So strict liability is the exception to having intent, and you can still get charged. But vicarious liability is interesting because this is the strong idea of a connection. Through a special relationship, liability for a crime can be passed to another. So intent doesn't matter for vicarious liability as well. So essentially, liability itself is looking at an exception to requirements of intent. The difference is strict liability is there's a set of crimes that if you do, you get in trouble for. Vicarious liability is you are connected. So, some easy to explain popular examples of vicarious liability. If you help somebody commit a crime, you did not commit the crime yourself, but you helped them successfully complete their crime, you are vicariously liable for their actions. You knew that what they were doing and you helped them. You have a special relationship, so the liability, the guilt of the crime can be passed to you. If you are a manager of a store and corporate says, hey, we need you to shred all these documents because we're in trouble, and you shred those documents, guess what? You're liable. You actually did it. But if you didn't do it, you could argue that they're doing the illegal action and you would no longer be liable for their actions. But it's also why a corporation can actually have corporate liability for when a individual gets hurt at an individual store. So things like the woman who got scalding hot coffee and got third-degree burns and sued McDonald's, McDonald's corporate had a vicarious liability. They had a corporate liability. Even though that one store is the direct reason for the pain and the charges, all of McDonald's was liable for it. And then, of course, more recently, there was the Crumbley family. And for those of you who don't know, a couple years ago, there was a young man, Ethan Crumbley, who was a school shooter. And his parents last year, actually I believe earlier this year, but were charged as partially responsible and liable for their son's actions. It's the first time that parents of a school shooter were held legally liable for their child's actions. And this is what we're talking about, is this responsibility, this relationship that exists led to being responsible for the criminal action. So I hope that helps explain this a little bit. I know it's a little funky the way I'm talking about it. By all means, if you're confused about any of this, please reach out to me. I'll be glad to try to explain it better or elaborate further. All right. So let's talk about causation and harm. So causation and harm is essentially like what we were talking about with liability. Okay, scratch that. Ignore that. Liability is looking at a way to determine responsibility without intent. Causation and harm is looking at other elements of crime that we don't typically discuss when we talk about the elements of crime, but they are relevant. Causation is exactly what it sounds like. What is the cause of the action? And harm. We use the term harm in a very particular way because harm is the negative outcome of a crime. If you remember all the way back a couple slides, we said not all criminal actions have to have a negative outcome. This is what we're looking at, is we're looking at harm. It's not necessarily a negative action, but we're looking for what exactly is the end result, and that's the harm. So we talk about causation and harm together. So causation, in fact, is looking for the factual start or cause, direct cause of harm. And there's a technical phrase that is essentially, if but for the defendant's act, the harm would not occur. That is the legal way to talk about causation, in fact. The idea is that if the person did not act in that particular way, the harm would not happen. So we are identifying the direct action that led to the harm. Legal causation, much like we've talked about in other contexts where there is due process in the way the law is written and how it's enacted versus the rights. So like causation in fact, where we have a factual one-point thing, legal causation looks for proximate causes. And if you're not familiar with that term, proximate means that it is around that point. It is not directly that point. It is not the direct cause, but it is in the area of. Proximate is related to proximity, so it's near. So we're looking for the near causes. And so the idea here is that the defendant's conduct must be closely related to the harm it causes. And again, a quote we use is, a reasonable person knows the act would result in a consequence. So in our first example of causation and harm, causation in fact goes, this action 100% leads to this response. Legal causation goes, look, a reasonable person would know that this is going to happen, but there's still a chance that it won't. And then there's intervening superseding cause. And this one is weird because something or someone interrupts a chain of events that is started by the defendant. The idea is that there's still harm being caused, but it puts the proximate cause further away. What we mean by this is that intervening superseding cause means that somebody started an action, started to commit a crime, and then somehow something interrupts the chain of events that would have led to a crime, that would have led to harm. However, now because the harm was delayed or changed, the proximate cause, the near cause that we could say technically they're responsible for it, gets pushed further away because it's not actually their input anymore. So again, this one actually is relevant to liability in the way that I'm trying to explain it. Much like liability, these are ways to expand on our criminal responsibility and ways of charging an individual for their criminal behavior. So these will be things that can make a sentence more severe. And so we need to talk about this in particular. So there's 1 year plus a day rules and 3 years plus a day rule. So very, very, very basically, in criminal homicide, the charge of homicide requires somebody to die. However, A victim surviving can complicate sentencing, causation, and harm. Because the idea here is that, can you prove that the act of attempting murder is what led to that person's death if they survived? And I know almost every one of you was like, yes, it makes perfect sense. If you tried to murder someone, that would be the reason they died. But legally, no, and it gets super complicated, and it's why we can have conversations about morality, because it's not related to this. It's a whole different conversation. Morally speaking, yes, this is a problem. But legally speaking, the idea is that victims must die within a certain time frame to be charged with, or charging the defendant for murder. Remember, there's a difference between, well, I guess we haven't really talked about it yet in this class, but there is a difference between murder and homicide. There is a difference between murder and homicide. Well, rather, manslaughter. Homicide is the overall thing. Murder versus manslaughter is very clear, and we're going to talk about it later in this class. Murder is you have the intention to kill someone. Manslaughter is it is a result of an action. It was not intended to kill. The issue with the 1 year and a day and 3 years and a day rules is that if a victim survives what would be a homicide and they die outside of these 1 year and a day and 3 year and a day rules, they can be lowered to a manslaughter rather than murder, because their death wasn't directly related to the actions. It gets really complicated and really stupid, and I understand why some people would be really upset. I'm just letting you know this now. But the 1 year and a day and 3 years and a day rules are essentially, if the person within 1 year and a day from when the crime was committed, or 3 years and a day from when the crime was committed, if complications arise related to that crime, they are still held responsible for that action. So if the defendant stabbed somebody and they were put in intensive care and they were put on a breathing respirator, they are still considered alive, and so that would not be murder yet. If they die within 1 year and a day of that official crime, they would still be able to be charged with murder, even though the murder happened over a year ago. Same would be applied for a 3 year and a day rule. Any time between when that initially happened and that 3 years plus 1 day, if something happened where they had complications and died, they would be responsible for that action. It would still count as murder. However, if it's outside of that time, it could be lowered to manslaughter because the intention might not have been there. And it gets really complicated. And again, I know why some people are definitely frustrated with this. This is not a statute of limitations situation. This is not a statute of limitations case. 1 year plus a day rules and 3 years plus a day rules are not statutes of limitations. They're related to it in the sense that statute of limitation is time limit, but they are not statutes of limitations. Statute of limitations is the time limit the government can prosecute a defendant. Technically speaking, if a victim survives well past the 3 years and a day, you can't charge them with homicide, but you can sure as heck charge them with attempted homicide. You can charge them with assault with a deadly weapon. You can charge them with a lot of things. But you can't charge them with murder. That's the important piece, and that's why I said it's not statutes of limitations. It's not, after 3 years and a day, if you haven't charged me with murder, you can't charge me with anything. No, I just can't charge you with murder anymore. I can charge you with something different. So it's really important to note that it's not statute of limitations, because it's not saying you cannot charge someone. It just changes the rules of the charging. And so in a weird roundabout way, because this in itself is related to causation and harm, in case you can't tell, because we're looking for causation in fact and legal causation. If we're talking about murder and homicide, yeah, technically speaking, the person has to die for it to count as that. If but for the defendant's act, the harm would not occur. And we want to charge them with it. We have to make sure that things are clear and straightforward and easily identifiable. That's the end of the PowerPoint. I want to go back to one slide in particular. Right here. Our elements of crime are criminal action, criminal intent, concurrence of the two. All crimes have to have an action, hopefully an intent, and a concurrence of the two, aka they're happening around the same time. Notice, very specifically, sometimes we don't need intent. If we have attendant circumstances, times where we don't need intent because of liability, then we look at something different. If the criminal act doesn't necessarily result in a particular way, we might be looking at causation and harm to determine how necessarily to charge the individual. Our elements of crime are this right here. We want to make sure that all of these things are getting addressed. We want to make sure that we understand we need a criminal act, we try to get intent, and we want them to happen around the same time when we are looking at it. That somebody didn't just act and then thought about it later, that it happened and it's connected. We want to look for causation, we want to identify harm, and if we need to, we want to identify attendant circumstances, things that change the rules, things that say we don't need necessarily criminal intent, things that mean, oh, we need to understand when criminal act is not an action. Those are the things we need to understand. Okay? That's it. Thank you very much. I apologize for this video. It's definitely a little more confusing and a little more all over the place, but I wanted to make sure that I got this out to you as quickly as possible. So please, if you have questions, if something does not make sense, please reach out to me, ask me questions, and I will be glad to answer them. Anyway, thank you, and I'll see you in the review video.